This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an arbitration clause in an insurance policy becomes void in the state of Louisiana, and why the United States Court of Appeal for the Fifth Circuit found it impossible to enforce the arbitration clause in policy, because the right of contracting parties to arbitrate is prohibited by a Louisiana statute. It's just not allowed in the state of Louisiana. Plaintiff SKAV, L.L.C, or SKAV, owns a Best Western hotel in Abbeville, Louisiana. The hotel was damaged when Hurricane Laura, one of the strongest hurricanes in state history, made landfall in August of 2020. SKAV submitted a claim on a surplus lines insurance policy it had purchased from Independent Specialty Insurance. The policy contained a broad arbitration clause requiring, quote, all matters in dispute, close quote, to be settled by arbitration. SKAV litigated the dispute, and the insurer asked that arbitration, in accordance with the contract of insurance, be compelled. In SKAV L.L.C. versus Independent Specialty Insurance Company, the United States Court of Appeal for the Fifth Circuit on June 5, 2024, was asked to answer whether or not Louisiana Statute Section 22:868 voids an arbitration provision in a contract for surplus lines insurance. SKAV sued Independent Specialty in the Western District of Louisiana, alleging that it had failed to timely and adequately cover the hotel's hurricane damage under the terms of the policy. The parties successfully participated in several months of court-directed mediation, after which Independent Specialty moved to compel arbitration. The district court denied the motion, concluding that Section 22:868 preempted the Federal Arbitration Act. The Fifth Circuit, analyzing the issues, noted that the parties primarily disputed what effect, if any, Section 22:868 of the Louisiana Revised Statutes had on the insurance policy's arbitration clause. The statute bars insurance policies from ousting Louisiana courts of jurisdiction and permits, in limited circumstances, forum and venue selection provisions. There was no dispute that the surplus lines insurance policy at issue in this case is under subsection D of the statute that stated it was not subject to approval by the Department of Insurance. Thus, the only question was whether the policy's arbitration clause faced by the Fifth Circuit is if that clause is barred by subsection A2 or permitted by subsection D. Many district courts in Louisiana, including some in New York, have reached conflicting decisions on this specific issue. One district court in the Eastern District of Louisiana certified the question to the Louisiana Supreme Court last year, but with two dissenting opinions, the state's high court declined to answer. The Fifth Circuit, as a federal court exercising diversity jurisdiction, needs to resolve this case as it thinks the Louisiana Supreme Court would rule. From the start, Louisiana courts have described Section 22:868 as memorializing an anti-arbitration policy. The statute does not expressly mention arbitration, but it bars insurance policies from depriving the courts of this state of the jurisdiction of action against the insurer, and Louisiana courts in turn have understood arbitration clauses to divest them of jurisdiction. The Fifth Circuit's reading of Section 22-868 concluded that the policy did not create a valid and enforceable arbitration agreement, and that when a statute prevents the valid formation of an arbitration agreement, as the Fifth Circuit read it, Section 22-868 it cannot therefore compel arbitration, even as a threshold question of arbitratability, because the provision was prohibited by statute. In my opinion, when a contract of insurance requires all disputes to be resolved by arbitration, it deprives the state of its jurisdiction to resolve disputes by means of its courts. The statute clearly and unambiguously deprived parties of the right to select arbitration over the state courts as the forum to resolve disputes over the terms and conditions of contracts of insurance. Since the statute prevents the formation of an arbitration provision, and the Fifth Circuit had no right to compel arbitration. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe to the videos. They're all free. And if you do watch the videos, I'd appreciate it if you click on the like button at YouTube and the thumbs up button on rumble.com. And if you're interested in further information about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. And please tell your friends and colleagues about this blog and the videos so that they too can subscribe. Thank you for your attention.